Yeah. So yeah, that was a good answer. What else?
In civil cases, generally it results to like monetary damages,
Yes.
and in criminal jail, including monetary damages.
Yes. Yes. That's the major difference. Very good. Who answered it? Anmol. Okay.
No, Tanaya. My name is Tanaya.
Tanaya. Okay, very good, Tanaya. So, yeah. So, in civil cases, basically what happens is that some kind of monetary aspect is involved, or some kind of rights related to a property is involved, or let's say some contract is involved. Whereas in criminal cases, usually it's a harm on the body of the person, or it is a crime against a society. So in criminal cases, usually the courts have the power to send the accused person to jail, whereas in civil cases, what the court at the best can do is that it can allow the claims, and it can get the relief, get the monetary relief to the plaintiff. Okay, so that's the major difference between civil and criminal. Now there are several kinds of civil cases. Okay, for example, uh, breach of a contract is also a civil case. Divorce is also a civil case. Then yes, a suit for eviction, for example, a landlord whose property has been occupied by a tenant illegally, and he wants the tenant to vacate the flat. That's also a civil dispute, civil suit. Okay. And let's say DRT, debt recovery, for example, the banks, like borrowers who borrow loans from banks and they later on fail to repay the loans. In such cases, banks take actions against the borrowers. Those proceedings also cover under civil proceedings. And what else? Partition suits. Okay. Uh, I mean, basically, the area is very, very vast. If you talk about civil suits, the area is very vast, and the law which is there in CPC is so huge and so vast that I actually cannot cover it up in one session, because there are different aspects related to civil suits under the CPC, which is actually required to be studied by you all, order wise. Okay, there are different orders and rules in the CPC, which I'm sure whenever you'll have the subject in your curriculum, you will read it. But today I will just let you know the basic requirements of a draft of a civil suit for recovery, not any other suit, but only recovery. Recovery, what do you mean by recovery? Recovery is of recovery of money. Okay, so basically it's a money lawsuit where one party claims that it has the right to receive an amount from the other party, based on whatever reasons, based on a contract, or based on a email agreement, or based on some commitment, whatever it is. But the party number one is entitled to get some amount from party number two, for recovery of which he or she files a suit for recovery. So let's start with the okay, no, first I would like to tell you that I was just reading somewhere what kinds of suits are usually taking place, usually filed in the courts in India. So if you see part 1 of CPC, so you will see the procedure laid down under part 1 of CPC is related to regular civil suits. Okay, so there are regular civil suits which include suits related to title of a property, suits related to some kind of redemption or rendition of accounts, or some monetary reliefs. So these all are covered under regular civil suit. Secondly, there are special civil suits. Special civil suits are filed against, for example, against some government employee or some government entity, uh, which is covered under part 4 of the CPC. Okay. Some kind of special permission is required for suing a government officer. That is also a procedure covered under the special civil suits. Then there are summary suits. In summary suits, what happens is that the procedure runs very fast. Usually summary suits are filed when when one of the parties has already admitted the claim but it is still not paying. So in such cases, what happens is that the plaintiff goes and files a summary suit and provides all the documents showing the admission from the end of the defendant. And the defendant is given only 10 days time to convince the court that he or she has a defense to the suit filed by the plaintiff. And within those 10 days, if he or she fails to come up with any kind of any kind of reasons for which he is not paying the paying party number one, then the suit is allowed. And the time limit is just 6 months, so it's a very faster procedure in summary suits. But it is also very difficult to get a summary suit allowed by a court, because you need to have a very 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 clean case without any complications. Admissions are required to be very clear from the other end, and then only a court admits a summary suit. Okay, and then comes suit tribal by court of small causes, which is very it's not very common although in India, because these are very small suits filed for 1,000 or 500 by before the courts of small causes, and these are very rare. So another aspect of civil suit is that you have to pay a certain court fees on the civil suits. Therefore, most of the parties refrain from filing a civil suit, because usually the court fees is very high. It is, if your claim is worth 60 lakhs, then you'll have to pay 3% of 60 lakhs as a court fee. So without which a suit is not admissible. So court fees is required to be, it's a very essential part of a civil suit. It has to be paid. Uh, okay, so the third part is pecuniary jurisdiction. First, you have to see where your civil suit will be filed, whether it will be filed in district court or in high court. So I'm sure you must be aware, if people here are from Delhi, then in Delhi, the pecuniary jurisdiction of a district court is 2 crores. So all the suits in which claims are worth 2 crores, they are filed up to 2 crores, they are filed before the district courts, and above 2 crores are filed before the high court. So first you need to check what is the exact amount your client is claiming from the defendant, and then you need to decide which court will have the jurisdiction. Okay, so coming to the short presentation which I prepared, slide number 1. So it basically says what is a civil suit, as I was just discussing with you all. A lawsuit which is not criminal in nature but purely civil. So purely civil means rights of a party rights of a party are under the threat of getting violated, or they have already been violated, or uh, one of the party, the plaintiff, is seeking some kind of injunction. I'm sure you must have heard about the word injunction, which is synonymous to the word stay order. For example, if somebody is having a doubt that his or her property is going to get affected if if the defendant is not stopped from doing something which he is doing continuously, then he or she can file a suit for injunction. That means suit for a stay order. So that suit can be for permanent injunction also, so that the court passes an order to stop or restrict the defendant from doing something which he or she was doing, which is affecting the right of the plaintiff. Okay. So secondly, the plaintiff may be an individual, business, or government entity. A suit can be filed by an individual or a business or a government entity. Anyone can file a suit before the court. He or she needs to prove before the court that what are the rights which he or she has, which is getting violated, and then he or she can file a civil suit. Third is defendant is sued by the plaintiff to protect, enforce, or to be compensated for violation of private rights. Now, these are private rights. As I remember, somebody rightly answered that in criminal cases, usually it is the state which is getting affected, the general public which is getting affected, whereas in civil cases, an individual's private rights are getting affected, because of which, or enforcement of for getting them enforced, a plaintiff has the right to file a suit before the civil court. So some common types of civil suits are, as I already told you, divorce, eviction, consumer protection, debt, or bankruptcy. Okay. So unlike criminal cases and civil suits, judges have the power to make the guilty pay fines, but not sending them to jail. Okay. So this is basically the definition of a civil suit. Now come to the next slide. This is basically the suit which we are covering today. It is under the Code of Civil Procedure, and it is basically a suit which has to be in a proper format. Now, there's a difference between suits under CPC and other suits. What happens in other suits like divorce, eviction, that merely by presenting the facts before the court in a proper manner, the court can admit those suits. But a suit under CPC, where you are claiming your rights under CPC, it prescribes a proper format. And if your suit is not filed under that format, then the other party can file an application under either the court on its own discretion, or on the basis of an application filed by the defendant, can reject your suit. That is covered. The grounds for rejection of a suit are covered under Order 7, Rule 11 of CPC, which you all need to read after this session. So one has to make sure that the plaint is has been drafted in a manner so that it doesn't get rejected on the basis of the grounds given under Order 7, Rule 11. Okay. Though, so there's a difference between suits under okay, yeah. So all right. So other suits can be filed just by presenting the facts of a suit, but a suit under CPC needs to be filed in a proper manner, in a proper format. So section 26(1) of CPC says that every suit shall be instituted by presentation of the plaint. As I am repeating the word plaint again and again, we get it from section 26(1) of CPC, that uh, or in such manner as may be prescribed. Section 26(2), what does it say? It says that in every plaint, facts are to be proved by affidavit. Now, whatever I say in a plaint, let's say I say that I am the owner of so and so property, okay, or I say that the defendant is my brother, okay, or I say that the defendant used to be my friend, but later on he started he occupied my property and he became a trespasser. I specifically told him not to come to my property, but he became a trespasser, so something like that. So all these facts which you state in a plaint, you need to prove them by way of affidavit. Now the affidavit which we file along with our plaint, that needs to be notarized by the notary official, and there's a specific language used in the affidavit which is very important. Anything which is said in the plaint is backed by that affidavit. So that is why if you see some affidavit which is filed in support of a plaint, it usually says that nothing material has been concealed thereof from this honorable court, and all the facts and circumstances which have been stated in the plaint are have been written as per my instructions given to my counsel, that means my lawyer, and nothing material has been concealed thereof. Also, the affidavit says that I am well aware about the facts of the case, and the facts which have been stated in the case are correct to my best possible view and knowledge. Okay, why a person needs to file such kind of an affidavit? Because you can write anything in your plaint. You can't just lie to the court. If you write something in a plaint and the other party objects to it, and the other party comes up with a document showing that the contents of your plaint are not correct, or they were not written correctly, then you are liable to be prosecuted under perjury. Okay, so perjury is a completely different area of practice. So if someone lies on the affidavit that the contents of the plaint are correct, then they are liable to be prosecuted under perjury proceedings. So that's why people usually refrain from stating anything which is wrong, or anything which cannot be proved by way of a documentary evidence in a plaint, because they are personally giving an affidavit in support of that plaint. Okay. So therefore it is very important for you that once you have drafted a plaint, you show it to your client and tell him to verify each and every fact of your plaint, so that nothing goes wrong before the court and nothing is pointed out later on by the defendant, which can end up being a troublesome situation for both you and your client. Okay, so the basic procedure is preparing the plaint. First you have to prepare the plaint as per the format, then you have to choose the proper place of suing. You need to see where exactly you have to sue the party, whether it's again it's a completely different section altogether, which you need to read first before drafting. So basically there are provisions in the CPC which say that in case of immovable property, where you should file a case; in case of some kind of movable property, where you should file a case, and which area will have the jurisdiction to deal with your plaint. That you need to first check, and then prepare your suit, then mention it in your suit and file it. Okay, so some of the essentials of suits of a plaint are of a suit are: first you need to see who all are the parties. Okay, your client, against how many parties are there, how many defendants, one, two, three, four, n number, there can be n number of defendants. If there are many defendants, you need to see whether all of them need to be made parties or some of them. Now then that's again dealt under the separate chapter of joinder misjoinder under the CPC only. So that basically prescribes the definition of proper party and necessary party. Necessary party are those without whom a suit cannot be heard or a suit cannot be decided at all, and or you can say the one against whom you have actually filed the case, or against whom you have actually sought the relief. And the proper parties are those against whom you do not seek a relief, but their presence is also important for adjudication of the suit. Okay, so you need to see how many proper parties and how many necessary parties are there. Accordingly you decide whom are to be made parties and whom are not required to be made parties. Next is framing of the suit. Framing is the kind of the language which you use in a suit. What are the facts, essential facts, which need to be provided? And institution, you have to institute it, you have to file it along with the court fees, requisite court fee before the proper court. Then cost, whatever is levied for filing the suit. And then format. So the format of a plaint is prescribed under Order 7, which is very important. You need to first see whether the exact pointers which are mentioned in Order 7, Rule 1, as per which you need to draft your suit, your plaint. Okay, I'm repeating it again, that if you don't draft your plaint as per the Order 7, Rule 1, then there are very high chances that the court will either return your plaint or it will dismiss it because of lack of proper drafting. So the first point which you need to mention in a draft in a suit for recovery is the name of the court. Now for example, uh, in the court of Honorable Mr. So and so, then you need to write the designation of that judge, whether he's a district judge or an additional district judge, and the name of the court. For example, in Delhi, there is Dwarka, Tisazari, Karkaduma, Rohini, whatever court. Then you need to write at New Delhi, the state you need to mention, and then you have to so that's the beginning of a suit. Name of the court, name of the court has to be properly mentioned. It can't be incomplete, just that you can't just mention before the court of district judge, and you don't write the state and you don't write the court. No, you have to write before the court of district judge. You have to, after that you have to write the designation. After, if you know the name, then you write the name. If you don't know the name, you leave it. That's also fine. And then you write the state. Okay, so after name of the court, you come to name, description. Okay, see, this is what has been given in the Order 7, Rule 11, Rule 1. But in the practical aspect, what we all do is, when we file a suit, We first write the name of the court, then we write in the matter of, the names of the parties, A versus B. That's how we write it. Okay. And then we write the cost, the exact title of the suit. Like, for what purpose have you filed the suit? Suit, for example, you write suit for recovery under so and so, for recovery of rupees so and so, filed on behalf of the plaintiff. This is how you write the heading of the suit. And after writing the heading of the suit, you come to the first para, which is the, no, come to the previous slide only. Any confusions until here?
No, ma'am.
No, ma'am.
Okay. See, some elements or some words which I use might sound very unfamiliar to you because you all are studying right now. We are practicing, so we understand those terminologies. But if you find any difficulty in understanding, please let me know, because clarity of concepts is the first and foremost important thing which is required to have in any lawyer who wishes to practice, who wishes to litigate. Just give me a moment. I am taking out one of my suits which I recently drafted. Okay. So first you write the name of the court. Then you come to in the matter of dash so and so, plaintiffs versus so and so defendants. Then you start with the heading of the suit, which is, for example, suit for partition, declaration, and permanent injunction. You all must be knowing what is a partition. So then you come to the next line, which is most respectfully showeth. This is something which in Indian courts we all write before starting any suit. Okay. So then we'll come to the element as per order 7 rule 11, that is the name, description, and place. Sorry, 7 rule 1, which is name, description, and place of residence of the plaintiff. For example, you write A. A is the plaintiff. You write in the first paragraph, A is working with so and so company and residing at so and so area. Okay. Or you write A is a peaceful and law abiding citizen of India and residing. Okay, so the document is actually in my phone, so as of now I won't be able to show you, but I'll definitely share a draft with all of you so that it becomes easier for you to draft a suit. Okay. So then comes, yeah, so I was on the description of the plaintiff. You describe what is the what is the plaintiff doing, whether he's a businessman or he's running a proprietorship firm, or he's a director of a company, or he's a government entity, or is he an individual. So the first paragraph you need to describe the plaintiff. In the second paragraph you describe the defendant, where you write the name of the defendant, the description as to what he does, what is his status, what exactly is he doing, as in is he a professional, is he a businessman, is he a proprietorship firm runner, or he's an individual, and you provide the address of the defendant if you have it. Okay, in para number 3. Usually in para number 4 we mention the relationship between the plaintiff and the defendant, so that the story which you need to narrate in the succeeding paragraphs becomes easier for the reader to understand. So in the fourth para, usually we write how plaintiff knows defendant, and how plaintiff and defendant came into touch with each other, either in a commercial due to some commercial relationship or due to some personal relationship, whatever. You need to describe that in para number 4. So then comes, if there are some particulars of a plaintiff, if required, if for example if a plaintiff is a minor or a person of unsound mind, or let's say indigent suits, you will be reading in your CPC later on, like if he's a pauper, or if he's an indigent, or if he's a minor, or if he's unsound mind, that statement needs to be there right after description of the parties. Okay, so you need to describe and you need to give a statement to that effect, that I am suing as a minor, or as an indigent person, or a pauper, or an unsound mind. Okay, so then comes the next para is all about the facts of the case. Facts can vary from case to case, whatever they are. So you just provide the exact facts which the client provides you, and try to be very specific while writing the facts. Don't just don't go by any flowery language or any hi-fi English, because courts and in district courts, usually people understand basic language used in a suit. Judges also get confused if you use too much of complicated English, or too much of flowery language in the suit. They find it very difficult to understand, and usually they don't actually try to understand, because they don't have so much time. So you keep it as crisp, as clear, and as short possible. But you